D2 that the second defendant blacklisted the claimant in reliance on the monthly returns and reports submitted by the first defendant. Under cross-examination, DW2 admitted that the second defendant blacklisted upon receiving the monthly returns forwarded to it by the first defendant together with a declaration from the bank that it followed due process before arriving at the decision as prescribed by the guidelines. DW1 tendered Exhibit 2D5, which is the review of operational guidelines for blacklisting. A direct confrontation of the competing evidence reveals deep and irreconcilable conflicts, which must be resolved by this court. On the material issue of whether the claimant committed or facilitated fraud, DW1's testimony that the claimant's password was compromised and that he connived to facilitate the fraud is directly contradicted by DW1's own admission under cross-examination. DW1 unequivocally admitted that the fraud was actually committed using the personal ID of Stephen Igbanoi, who was on leave, and not the claimant's ID. Furthermore, DW1 admitted that the Manuela Agbo retracted the assertion that she shared the password with the claimant. This retraction is collaborated by Exhibit D2 itself, with records that the claimant denied receiving the password and that the Manuela retracted the allegation. Therefore, the first defendant's allegation of fraud rests on absolutely nothing but a retracted statement and a speculative theory of password sharing, which does not even involve the password that was used to perpetrate the fraud. In the process of evaluating these exhibits, the court was appalled that the first defendant did not call Stephen Igbanoi, the officer whose ID was actually used to access the system, nor did they call Emmanuel Agbo to testify before this court. While the law does not impose an obligation to call every possible witness, where a party's case relies entirely on an allegation of crime that has been retracted by the key accuser during the internal disciplinary process, the failure to call that vital witness to give effect, to give direct, tested oral testimony before the court creates a fatal gap. It must be noted that an uncontroverted denial by the claimant under oath remains far superior to a retracted, uncross-examined statement. This court finds CW1's of proof beyond reasonable doubt required for allegations of fraud under Section 135 of the Evidence Act. If the commission of a crime by a party to any proceeding is directly an issue in any civil or criminal proceeding, it must be proved beyond reasonable doubt. The first defendant bears the heavy burden of establishing the allegation of fraud to that high standard, and it cannot rely on mere suspicion, speculation, or shifting narratives. See Section 135, Sub 1 of the Evidence Act. See also Abubakar and Joseph 2008 citation provided. Breach the fair hearing provisions of the operational guidelines. The submission of the claimant's name to the second defendant for blacklisting was entirely wrongful, illegal, and unjustified. On the first issue, I find in favor of the claimant. Now, on the material issue of fair hearing, the first defendant the fair hearing procedure is outlined in Exhibit D8, and it is quite precise. It requires that the financial institution notify the staff member in writing that a complaint for blacklisting has been filed against him, detailing the specific grounds and consequences, and afford him a full opportunity to present his defense, with the final decision communicated to him in writing. See Section 36 Sub 1 of the Constitution as amended, and see also Garba and University of Maiduguri 1986 citation also provided. The first defendant's assertion that the claimant was afforded a fair hearing because he attended the panel is confronted by CW1's evidence that he was never formally invited, was never notified of any blacklisting complaint, and was merely conscripted from his desk to answer questions. This court shall resolve this conflict by reference to the strict provisions of Exhibit Exhibit C8 and Exhibit 2D5. The guideline laid down a mandatory 4-step fair hearing procedure, which includes first, notifying the staff in writing that a complaint for blacklisting has been filed against him, detailing the specific grounds and consequences. Second, allowing him to present a defense. Third, conducting an impartial hearing. And fourth, communicating the final decision to him in writing. The first defendant The evidence shows that the first defendant completely bypassed this standard, these safeguards. CW1 testified that, and I quote, "I attended the panel set up by the first defendant to investigate the alleged fraud. I was not formally invited. I was never given notice that a complaint of blacklisting has been made against me. I was summarily summoned into the session of the panel on 2 occasions, so I was never given any opportunity to prepare for a defense since no formal accusation was communicated to me." Under cross-examination, CW1 admitted that he appeared before the panel, but clarified that I was asked only one question, and that would not have given me the opportunity to express myself. The first defendant did not produce any written notice, invite, or query sent to the claimant regarding blacklisting, nor did he show that the final decision was ever communicated to him. Indeed, inviting an employee from his desk or workstation to an ongoing panel to answer a single question as admitted by the claimant and never rebutted by DW1 does not satisfy the requirement of natural justice or the specific procedural safeguards mandated by the CBN. This court finds that the first defendant's failure to follow its own regulatory guidelines constitutes a flagrant breach of the claimant's right to a fair hearing, as guaranteed under Section 36 of the Constitution. To satisfy the Constitution and the regulatory standard of a fair hearing, a party must be given adequate notice of the specific allegation against him and a reasonable opportunity to prepare and to present his defense. The court must robustly reject the first and the second defendant's contention that the mere physical presence of the claimant at the panel satisfies the requirement of a fair hearing. To satisfy the constitutional and regulatory standard of fair hearing, a party must be given adequate notice of the specific allegations against him and a reasonable opportunity to prepare and present his defense. From CW1's account before this court, which was never rebutted, he was invited from his desk to appear before an ongoing panel session to answer a single question. At that panel, it was never disclosed to him that his name was being considered for a career-ending blacklist register. This, to the mind of this court, is a sarcasm of natural justice and falls short of procedural fairness. There is also a profound inconsistency and gap within the first defendant's own evidence. In his amended statement of defense and DW1's deposition, the first defendant pleaded that the claimant's password was compromised. Yet, the disciplinary committee report Exhibit D2 contained no such finding, but rather focuses on an allegation that Emmanuela Agbu shared a password with him. To worsen the contradiction, Exhibit D4, which represents the executive committee consideration and ratification of the disciplinary committee's report, shows that the EXCO did not find the claimant guilty of any fraud, but simply recommended that he be returned to his employer and that the EFCC investigation should continue. This is a massive gap in the first defendant's case. If the EXCO of the bank did not find the claimant guilty of fraud, but merely returned him to his employer pending EFCC investigation, there was absolutely no legal or factual basis for the first defendant to forward his name to the second defendant for blacklisting as a terminated, dismissed, or convicted staff on the grounds of fraud. This inconsistently directly supports the claimant's contention that his blacklisting was whimsical, hasty, and unjustified. Furthermore, the court noted that the guidelines in Exhibit C8/D 2D5 strictly limit the blacklisting of individuals to those who have been terminated or dismissed strictly as a result of fraud, dishonesty, or conviction. The claimant was never a permanent employee of the first defendant. He was an employee of Vic Lawrence and Associates Ltd, who was merely seconded to the first defendant as evidenced by Exhibit C1. Following the disciplinary investigation, the claimant voluntarily resigned from his employment with Vic Lawrence and Associates Limited on March 9, 2021, as conclusively proven by Exhibit C2, which is his letter of resignation. He was neither terminated nor dismissed by his direct employer, nor was he terminated or dismissed by the first defendant. By forwarding the name of an employee who voluntarily resigned, the first defendant acts in flagrant disregard of the clear boundaries of Exhibit C8. An employer cannot blacklist an employee who has resigned without any substituting indictment of fraud ratified by its management. The failure of this primary condition precedent renders the entire blacklisting process procedurally invalid from its inception, as a court of law will not allow an administrative action to stand when a statutory condition precedent has been bypassed. In line with the classic authority of Madukolo and Nkemdilim, the first defendant's defense of regulatory compliance is untenable. With respect to the second defendant, the CBN, its counsel argued that the second defendant cannot be ordered to delist the claimant because it merely acted in good faith on the returns forwarded by the first defendant, and that under clause 10.0 of the guidelines, a court order must precede any delisting. While this court accepts that the second defendant acted as a regulator in receipt of returns, once it has been established before a court of competent jurisdiction that the underpinning of the blacklisting were false, procedurally flawed, and obtained in gross violation of the right of fair hearing, the blacklist cannot be allowed to remain. Indeed, clause 10.0 of the operational guidelines expressly recognizes that a blacklisted person can be delisted upon the court's order. This court, having found the delisting to be wrongful and illegal, the second defendant has a statutory and regulatory duty to immediately expunge the claimant's name from its blacklist register, I so find and hold. Now, the second defendant defense also that it acted in good faith is also not a bar to the claimant's relief. Good faith on the part of the regulator cannot cure a fundamentally void, illegal, and unconstitutional act of the initiating bank. Once the foundation of the blacklisting is shown to be non-existent, specifically that the claimant resigned and was never dismissed nor terminated for fraud, the entire administrative edifice of the blacklist collapses. The law does not permit an illegal act to stand merely because the regulator acted in good faith on false returns. Indeed, clause 10.0 of the operational guidelines in Exhibit 2D5 expressly recognizes that a blacklisted person can be delisted under a court order. This court, having found the blacklisting to be wrongful and illegal, the second defendant has a statutory and a regulatory duty to immediately expunge the claimant's name from his blacklist register, as earlier determined by this court. This court must also address the first defendant's highly technical argument that because the claimant did not specifically seek a relief to set aside the internal disciplinary committee report Exhibit D2, this court lacks jurisdiction to grant relief against the blacklist. This argument is a complete legal non sequitur. A party is not required to challenge an internal uncommunicated and preliminary disciplinary report because seeking a remedy for a subsequent distinct and highly public wrongful act such as blacklisting. The cause of action arose when the claimant's employment offer with Network International Payment Services Nigeria Ltd was terminated on February 21, 2023, as proven by Exhibit C4 due to the failed background check, not when the internal panel finished its secret sessions. The blacklist is the injury. The report is merely part of the background. To hold that an employee must first seek to set aside every internal report of an employer before challenging a wrongful public registry blacklisting would be to erect an artificial, non-existent barrier to justice. Consequently, this court finds that the first defendant completely failed to prove any act of fraud or dishonesty against the claimant, failed to comply with the mandatory conditions precedent of termination or dismissal, and flagrantly breached the fair hearing provisions of the operational guidelines. The submission of the claimant's name to the second defendant for blacklisting was entirely wrongful, illegal, and unjustified. On this basis, I find in favor of the claimant, I so hold. The second issue for determination is whether, having found that the submission of the claimant's name was wrongful, is the claimant then entitled to an apology, damages, and an order of delisting from the blacklist. It is a fundamental maxim of equity and law that where there is a wrong, there must be a remedy. Ubi jus ibi remedium, as established in the landmark case of Bello and Attorney General of Oyo State. The wrongful inclusion of the claimant's name in the second defendant blacklist register is not a tribal administrative error, it is a permanent professional stagnation. The blacklist register of the CBN is designed to exclude individuals of questionable characters from employment within the entire financial and banking sector of the country. To wrongfully place an innocent young professional's name on such a register is to permanently destroy his reputation, stagnate his career, and deprive him of his livelihood. The devastating impact of this wrongful act is fully established by the evidence. The claimant proved that he secured an employment offer from Network International Payment Services Nigeria Ltd on November 2, 2022, with a monthly salary of 450,000 naira as evidenced by Exhibit C3. However, on February 21st, 2023, this employment was abruptly terminated. Exhibit C4, which is the later titled Failed Background Check, states in clear terms that his employment was terminated solely because of a failed background check, showing that his name was on the CBN second defendant blacklist register. The first defendant's contention that the claimant is not entitled to damages because the bank acted in good faith and to protect the financial sector is also untenable. A party cannot hide under the cloak of good faith when his actions are characterized by gross procedural irregularities, failure to investigate, and reckless regard of the rights of the employee. The plea of good faith or regulatory compliance cannot validate an administrative action carried out in gross violation of procedural natural justice or where the action completely lacks factual basis. The bank suffered a fraud of 827 million naira, which is indeed a serious matter, but does not give it a license to incriminate an innocent officer whose part word was never used and against whom its own executive committee found no guilt. The injury suffered by the claimant, the loss of his job, the destruction of his career prospects, and the severe psychological trauma of being branded a fraudster flows directly and naturally from the first defendant's wrongful and lawful submission of his name to the second defendant. In the circumstance, the claimant is fully entitled to general damages to compensate him for the severe injury to his reputation and career. General damages are such as the law shall presume to be the direct, natural, or probable consequence of the act complained of, and the assessment is within the sound discretion of the court as guided by the decision in UBN and Adams Ajabule 2011 citation provided. Having regard to the loss of his employment, where he earned 45,000 naira monthly, the career stagnation of over 2 years, and the profound damage to his professional reputation, this court assesses and awards general damages in the sum of 20 million naira against the first defendant. Furthermore, because the wrongful blacklisting has severely tarnished the claimant's standing in the financial industry, a monetary award alone is insufficient to fully restore his character. The claimant is entitled to a written apology from the first defendant to assuage the injury to his reputation. On the second issue, I find also in favor of the claimant. In conclusion, the court makes the following net evidential findings on the issue. First, the first defendant failed to prove any act of fraud, dishonesty, or password compromise against the claimant, and the standard of proof beyond reasonable doubt was not met. Second, the first defendant failed to afford the claimant a fair hearing as mandated by the common law and the explicit provisions of the CBN guidelines. Third, the mandatory condition precedent for blacklisting that the person must have been dismissed or terminated for fraud was completely absent. As the claimant voluntarily resigned his employment. Fourth, the wrongful and unjustified blacklisting directly caused the termination of the claimant's new employment with Network International Payment Services Nigeria Ltd, as proven by the C4, resulting in severe career stagnation and financial loss. These findings are carried forward for final determination. Overall, the judgment is entered for the claimant and the court makes the following orders. 1. It is hereby declared that the first defendant's submission of the claimant's name to the second defendant for inclusion in his blacklist register was wrongful, illegal, and a flagrant violation of the CBN review of operational guidelines for blacklisting and the claimant's right to a fair hearing. 2. The second defendant is hereby ordered and directed to immediately delete the name of this claimant, Tayo Wale Oshin, from his register of terminated, dismissed, or convicted staff of banks and other financial institutions on the grounds of fraud and dishonesty, otherwise called the blacklist. 3. The first defendant is ordered to apologize in writing to the claimant for unjustifiably forwarding his name to the second defendant to be included in the register of terminated, dismissed, or convicted staff of banks and other financial institutions on the grounds of fraud and dishonesty within 30 days from the date of this judgment. 4th, general damages in the sum of 20 million naira is hereby awarded against the first defendant and in favor of the claimant for the wrongful blacklisting, loss of employment, and injury to his professional reputation. Cost of this action is assessed at 1 million naira. The defendant shall comply with the orders of this court within 30 days from today, failing which the entire judgment sum shall attract interest at the rate of 10% per annum from the date of this judgment until it is fully liquidated. Judgment is entered accordingly.
This is
the judgment of the court.
Injunction of the law and
As the court pleases.
young man can have a new lease of life. We are very grateful, madam.